You might think your family trust protects your assets in a divorce. The truth, in the wrong circumstances, the court can reach straight in and treat those assets just like they're yours. And when that happens, your protected wealth can disappear very quickly. I'm Hayder Shakara from Collective Family Law Group. We specialize in complex property settlements, especially when trusts and companies are involved. And in this video, I'll walk you through exactly how the family court treats trusts, when they're safe, when they're not, and the practical steps you can take to protect them. Okay, so firstly, a trust isn't a legal entity, it's a relationship. A trustee holds legal title to assets for beneficiaries according to the trust deed. That deed sets the rules, and the real power usually sits with whoever can hire and fire the trustee or veto decisions. Why this matters in family law is simple. The court isn't just asking whose name is on the title, it's asking who effectively controls these assets and for whose benefit have they been used. Under the Family Law Act, the asset pool is property of the parties. Trust interests can fall into two buckets. First, trust assets can be treated as property if one party has such effective control that the trust is essentially their alter ego. Think appointed powers, the ability to replace the trustee, a track record of directing distributions to themselves, and using trust assets like it's their personal bank account. In that scenario, the court can treat trust assets as available for division. Now, in the second scenario, where control is limited, say in a wider discretionary trust where there are independent controllers and the party that we're talking about is just one potential beneficiary with no fixed entitlement, the interest is usually considered a financial resource rather than property. It still affects the overall outcome because future distributions can be taken into account, but the trust isn't dropped into the asset pool dollar for dollar. It's not like an asset. Now, the line between these two outcomes turns on control, history of use, and the trustee. And when the judges look through a trust, they don't rely on labels, they trace power. Here's how that plays out in practice. We start with the deed. Who is the appointer? Can they remove the trustee at will? Are there default beneficiaries if no distribution is made? What powers exist to add or remove beneficiaries? Then we start looking at what's been happening in reality, and that means who's been making decisions, who signs off on trustee resolutions, where do the distributions actually go? If the controlling mind is the spouse and the pattern of conduct shows personal use, it's far easier to characterize the trust as their effective property. Finally, we examine how the trust was funded. If the original amount was coming from the spouse's pre-relationship assets, loans from them, or rollovers from other entities that were under their control, it does strengthen the alter ego argument. If it came from, say, a parent's estate with genuine independent controllers, then potentially it could be considered a financial resource. Australian courts have confirmed that in the right circumstances, trust assets can be treated as the spouse's property, even if the legal title sits with the trustee and not with the spouse themselves. The key theme is the same one I've just explained: powers plus conduct. If the trustee might be bound by any orders, or if evidence is needed from the trust, you should be considering joining the trustee company to the proceedings. That can mean compelling the trustee to provide records, restraining them from dealing with any trust assets, or if need be, effecting transfers or payments. Family law requires full and frank disclosure. With trust, that usually means giving all of the documents over to all parties involved so they understand what they're dealing with. That could mean the trust deed, it could mean different trustee resolutions, financial statements, tax returns. All of this is to help understand what the nature of the trust really is. Now let's talk about debts, liabilities, and any attempts to try and diminish the trust. The court's going to look very closely at the commerciality of any of these things. Genuine business debts do reduce the value of a trust. However, artificial liabilities taken on during separation or around the time of separation to try and diminish the value of a trust. Maybe you might see mysterious new related party loans or last minute consulting invoices. All of that is going to invite scrutiny from the court. If the court concludes that a transaction was designed to defeat the other party's claim, it can set it aside or notionally add back the value to do justice to the other party that missed out. Now, if it's found that trust assets are property, they're going to be added into the pool and divided at step 4 of the usual family law process after contributions and future need adjustments. I'm going to run through some plays that you could consider if you're dealing with a trust in a divorce settlement. One is offsetting. The controlling spouse could keep the trust and trade value elsewhere. It could be by giving more real property, superannuation, or cash. Another way of handling this would be by stage payments, which could be secured installments funded from future earnings instead of having to sell assets or anything else in the trust in order to diminish it. Sometimes you restructure or refinance the trust, or you might move assets to be sold so you can meet your obligations without gutting operations. Here are two brief case studies to anchor these concepts. In one matter, the husband was appointer and sole director of the corporate trustee. The trust owned the trading business and two investment properties, and for a decade, distributions went to him or his bucket company, and the trust paid private school fees and home renovations. In this case, we treated the trust as his property, valued the net assets, and negotiated that he retain the trust while the wife received more of the real estate outside the trust, plus the secured cash adjustment over 24 months. There was no sale, no disruption, no added tax consequences, and a just and equitable division that both parties could live with. In another case, a wife was a discretionary beneficiary of her parents' trust. She had no appointed power. Her brother and an accountant were controllers, and there were irregular distributions for gifts, but no pattern of control or spending from the trust. We characterized her interest as a financial resource only. The overall split moved a few percentage points against her to reflect her potential benefit, but the trust stayed off the property schedule. Trusts don't magically protect assets in family law, but they aren't automatically vulnerable either. Outcomes turn on deed powers, real-world control, funding history, and how smartly you plan the settlement and taxes. If your matter involves a family trust or a web of entities, get specialized advice early. I'm Hayder Shakar, and at our law firm, we deal with these matters all the time. Book a consultation and we'll map a strategy that protects your position and gets you to a workable deal. And if this deep dive helped, subscribe for more advanced guides on high net worth and business owner separations.